Greetings, Mayor, Mayor Pro Tem, members of the City Council, members of the public. This item is regarding the tenant anti-harassment ordinance. This is Alba Marshall, the Rent Stabilization and Just Cause Eviction Program Supervisor for the Oxnard Housing Department Rent Stabilization and Just Cause Eviction Program. Background. Recently, there has been an increase in the number of cases reported against landlords who are employing coercive tactics to induce tenants to vacate their rent-stabilized units. Reported tactics include reducing housing services, issuing eviction notices based on false grounds, threatening to contact immigration authorities, or refusing to conduct repairs required by law, subsequently leading to tenants being forced to vacate through these tactics, oftentimes allowing landlords to raise rents to market rate rent without abiding by the city's 4% rent caps for applicable units or going through the city's fair return petition process. Several jurisdictions such as Santa Monica, West Hollywood, Oakland, San Jose, and Los Angeles have seen similar trends, resulting in the adoption of tenant anti-harassment ordinances. It is reported that these ordinances help serve as a deterrent to illegal conduct and assist tenants in their legal defense against landlords who engage in such harassment. In response to escalating reports of landlord harassment in Oxnard, staff was asked to bring forth a tenant anti-harassment protections ordinance for City Council's consideration. Tenant anti-harassment ordinance. Housing staff engaged Stephen Lewis, Esquire, to prepare a tenant anti-harassment ordinance. Mr. Lewis is an attorney with nearly 30 years of experience related to rent stabilization and just cause evictions and tenant protection ordinances. When drafting the proposed ordinance, Mr. Lewis incorporated best practices from the various jurisdictions consulted, while also ensuring the ordinance did not violate any constitutional protections or publish appellate opinions. The proposed ordinance prohibits harassment by residential landlords and identifies specific acts and omissions by landlords that constitute prohibited harassment. Violations under the ordinance is a misdemeanor and may be criminally prosecuted by the city. Based on the experience of other jurisdictions with similar ordinances, only the most egregious cases are prosecuted as violations of tenant anti-harassment laws. The ordinance also allows an aggrieved tenant, the city, or an organization to pursue civil action for damages and the recovery of attorney fees. The ordinance would apply citywide to all residential tenancies within the city. On March 25th, 2025, staff introduced a draft tenant anti-harassment protections ordinance to the Community Services, Public Safety, Housing, and Development Committee. At this meeting, staff received input from the committee, public, and various community stakeholders. There were a number of changes requested. Consensus was reached amongst the stakeholders and committee members for 2 changes, which are further described below. Section 27-42A3 addresses an owner's right to access a rental unit. A request was made to add language specifying the hours during which entry is permitted. In response and in collaboration with community stakeholders, staff proposes adding the following subsection. V5, entries outside of normal business hours, which are defined as 7 a.m. to 7 p.m., Monday through Friday, and Saturdays, 8 a.m. to 12 p.m., except in cases of emergency or when the tenant has abandoned or surrendered the premises. Entry may not be made during other than normal business hours unless the tenant consents to an entry during other than normal business hours at the time of the entry. Section 27-42A10 was amended to clarify good faith. This subsection shall not apply to communications and conduct that are made in connection with actual pending litigation or litigation preparation, including any communications and conduct subject to Civil Code Section 47 in conjunction with the good faith requirements stated in Action Apartment Association Incorporated versus City of Santa Monica 2007, 41 Cal 4th 1232. In preparation of implementing the proposed ordinance, staff reviewed over a dozen anti-harassment laws to better understand staffing, budget, and outcomes associated with the implementation of their respective laws. Based on this research, staff recommends an approach in alignment with the City of Santa Monica, which has a standalone anti-harassment ordinance that covers all residential tenancies within the city. The ordinance applies to 33,505 renters as identified in their housing element report. The City of Santa Monica receives approximately 200 complaints a year, and on average, 5 to 10 of those result in litigation. Each of those complaints warrants a thorough investigation, which often results in substantial staff time needed to prepare these cases prior to the city attorney's office receiving them. Santa Monica's ordinance is administered by the city attorney's Consumer Protection Unit, which is staffed by 5 lawyers, 2 investigators, and support staff. Implementation. Adoption of a tenant anti-harassment ordinance would be ineffective without adequate staffing and resources to enforce the ordinance. Staff estimates that approximately 22,327 housing units are subject to the ordinance. To launch a comprehensive citywide program, the Housing Department requests authorization to hire 2 positions, one partially dedicated assistant city attorney and one fully dedicated housing investigator. The assistant city attorney will conduct legal research, prepare opinions and regulations, prosecute civil or criminal violations related to the tenant anti-harassment ordinance and other municipal codes, and represent the city in a variety of litigation. The housing investigator will investigate tenant complaints, conduct research, interview witnesses, prepare reports, and make referrals for criminal prosecution or civil litigation or to nonprofit organizations. An annual budget of approximately $500,000 and $500,000 is needed to support the 2 positions, including benefits and fixed charges. The 2 positions associated with this ordinance will be included for council's consideration of the fiscal year 2025-2026 budget. Therefore, if the ordinance is approved on April 29th, the ordinance will not come before council for adoption until after consideration of the fiscal year 2025-2026 budget. An ordinance does not go into effect until 30 days after adoption. This means at the earliest, this ordinance will not be effective until at least the end of July. Recommendation that the City Council review and approve the first reading by title only and waive further reading of the proposed ordinance titled Ordinance of the City of Oxnard, California, adding Article 3 to Chapter 27 of the Oxnard City Code, establishing tenant anti-harassment protections, and authorize 2 full-time equivalent positions and the associated budget as part of the fiscal year 2025-2026 budget for implementation of the proposed ordinance. This is the end of the presentation. Thank you for your time.